Yes, I know, I've slackened the pace deliberately. But let me welcome you today, yet again, to another YouTube episode of Nagorno-Karabakh, and this one is number 11. Now, before I go into the meat of the matter, let me do what I usually do with these episodes, and that is to share with you a few links in the description box. So today there are 4 links, and I'd encourage you to read them, look at them. Maybe they might be helpful. The first one is almost standard by now. It's host, guest, Eric Hakopian on CivilNet TV, talking about the political realities of Armenia today. The second one, which is some 10 years old, so it's quite old, is by Dr. Irina Ghaplanyan, and it is interesting, in my opinion, because it focuses on the possibility of empowering and engaging civil society in conflict resolution. A third link takes you to the Caspian Sea battleground. And the question is, was this Nagorno-Karabakh war a cause or a consequence of the Caspian Sea battleground? I think there are some quite interesting thoughts in there. And finally, last but certainly not least, a briefing by Crisis Group International on the prospects for peace in Nagorno-Karabakh. So once again, welcome to number 11 of my YouTubes on this conflict, which was for almost 30 years frozen, but has suddenly become very, very volatile. And today what I'm going to do is try and wear my public international lawyer's hat and only share with you some thoughts, some seeds. It's well nigh impossible to go into the details, just some thoughts about the legal aspects of what is happening around this conflict now that the war has ended. And in doing so, based pretty much on conversations I've had with colleagues and also friends, there are 2 issues that I keep hearing. One is a broad issue and the other one is a narrower one. The broad issue in layman's terms is, to whom does the enclave or Nagorno-Karabakh belong? I've talked about this in the past. I've referred to it, the whole discussion on self-determination, secession, territorial integrity, but it is one that is coming up again, particularly now that the enclave itself is pretty much divided, with Azerbaijanis and Armenians living in it, almost as neighbors, and that of course is leading to tensions and to skirmishes. The narrower issue is that of prisoners of war, war crimes, crimes against humanity, what happens to those people who have disappeared and haven't shown up yet, civilians, etc., etc. So in a sense, what I'm trying to do with those few thoughts, very brief thoughts in such an episode, is to identify the locus standi. In other words, where does one have the right to be heard on these issues? Should it be in the UK? Should it be in the diaspora? Or should it actually be in Armenia? Now, there are 3 options I'm going to share with you, and I leave it open for lawyers, politicians, sociologists, and interested parties to think about it. The first one is, if we look at things locally, would we be tempted to look at the High Court, to seize the High Court, and in a sense constitute a resident claim that would be helpful for further legal action, either in this country or abroad, such as in Armenia itself? What about a judicial review in the High Court that would actually specifically test whether an individual or group has been directly affected by the situation in Karabakh, or whether this would be thrown out as a vexatious litigation. Now, that is one way. Another way is whether an opinion could be done by a QC, a solicitor, a barrister, an eminent lawyer. The way I've seen opinions being written down on the Armenian genocide of 1915, in order to share ideas about those two issues, whether the broader one or the narrower one. Is this the way to go? Remember that in a previous Court of Appeal ruling, the court judges said that the appellant must have an adequate interest in the subject matter of the litigation, that the interest must not be too remote, it must be actual, and it must be current. And without going further into the details, I think those are four relevant and quite appropriate tests to see whether one would go to the High Court, would seize the High Court or not. But then going a little bit beyond the borders of England and Wales or the United Kingdom in general, and going, for instance, to The Hague in the Netherlands, there are two options that come about, one for the narrower one and one for the broader one. Now, the first one, of course, and that has been talked about quite a bit as well, is the ICC, the International Criminal Court. Now, remember that the ICC prosecutes individuals, not groups or states. In other words, any individual who is alleged to have committed crimes within the jurisdiction of the ICC may be brought before it. In other words, if Armenians claim that Azerbaijan, the soldiers, politicians, whoever have committed crimes, then an individual is allowed to bring a claim in front of the ICC. But an immediate question comes to mind. The two countries, Armenia and Azerbaijan, are not signatories of the Statute of Rome. In other words, they do not recognize the jurisdiction of the ICC. So even if the Prosecutor General of the ICC were to say, yes, I would look into this issue, albeit rather far-fetched scenario, then it is very easy for Azerbaijan to say, I dismiss this, I'm not interested in the ICC. Now, some people have told me, well, what if Armenia becomes a signatory of the ICC? Would that make a difference? Well, it might make a difference in the sense that Armenia becomes part of that legal community. But if Azerbaijan does not become signatory, then Azerbaijan has every right to dismiss any decision taken by the ICC. So till now, the High Court, domestic, then the ICC in terms of POWs, in terms of war crimes, in terms of whether that is the right way to do it. And if you go down that road, would it be fruitful as a remedy or not? And of course, the third one on the broader issue is the question of to whom does Nagorno-Karabakh belong? Now, this is something that has been mooted for so long. And the ICJ, the International Court of Justice, also based in The Hague in the Netherlands, unlike the ICC, both Azerbaijan and Armenia have been members since 1992. And the question there, of course, is, would it be to ask the ICJ for a judgment on the matter, or would it be to ask for an opinion? Now, as far back as 2004, I was involved in the case of the separation wall between Palestine and Israel that went for an opinion to the International Court of Justice. The opinion that was issued was, in my mind, very fair and very useful. But of course, an opinion is not binding. So Israel ignored it. The separation wall continued. Some call it security wall, some call it apartheid wall. I call it a separation wall. Continued, and it ate into Palestinian territories. It encroached upon Palestinian territories as it was built. So having an opinion from the ICJ is not really an answer. Now, some people would say, yes, Harry, but what about the advisory opinion of the ICJ on Kosovo's declaration of independence? Though it did not support Kosovo's ability to unilaterally declare itself as a state, it's interesting that the ICJ there did not rule against the move as a violation of international law. In other words, this legal organ left open that such declarations of independence could create a state. Three avenues, food for thought. I'm sorely aware that I'm leaping across boundaries without explaining too much, but that's because I cannot do so in this short episode. This is, again and again, I say, seeds for thought, food for thought for those committed to these issues, in this case, Nagorno-Karabakh. The High Court in the UK, an opinion by an eminent QC or barrister in the UK, the ICC, the International Criminal Court, the ICJ, the International Court of Justice. But at the end of the day, let me leave you with some thought. If we're going to go down the legal route, if Armenians are going to go down the legal route, whether in the diaspora or in the Republic itself, whether individuals or groups or states becoming parties, it's important that whatever is done is not premised on ideological grounds. Ideology does not have much to do with the law, nor emotional frustrations, anger, vindictiveness. That has nothing to do with it. Either party, be it Armenia, Azerbaijan, any party in any legal situation should divest oneself of ideology and unnecessary rampant emotions and only focus on the law, what is probable and what is not probable. High Court, ICC, ICJ. There's a lot more that could be said about this. But also remember that when we Armenians, and I'm speaking as a member of that tribe, so I know that some people might say, hey, we have a counter argument. Of course you have a counter argument, because we might have a claim as Armenians, but there is nothing that prevents Azerbaijan or any other party to counterclaim with their own interpretation of public international law or of the domestic remedies available in such instances. I hope this was slightly helpful, at least as, again, I say it ad nauseum, food for thought, as ways to trigger some more directions in people's understanding of how the law works. And as I do that, I hope that the peaceful situation in Karabakh remains, at least for the moment, until it becomes clearer where we're going, because it is an untenable situation, in my opinion, what we have now. And let me remind all those who are keen to pursue the legal pathway in this case, that at the end of the day, this conflict is not a legal conflict. This conflict is certainly not a religious conflict. It might be interpreted as ethnic, but at its core, it's a political conflict. And therefore, politics has a lot to do, not only with the causes and consequences, but also, hopefully, with the solutions. Take care and all the best.